Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. Today we are talking about Darrell Brooks, but before we get to that, remember this, as all of our episodes are brought to you by eforms.com. What did I say? eforms.com. If you need a legal form for any purpose, let's say you want to kick your grandmother out of your house because she's eating Cheetos in your basement and running up your porn bill. Well, you get a eviction form from eforms.com and you get rid of her. Or let's say your grandma, she is so sweet and she's aging and you want a power of attorney because you want to help take care of her affairs. You go to eforms.com. Why hire a guy like me when you can get it done for yourself for next to nothing? And that's where I would go anyway if I needed a form. So go to eforms.com. Now, we are here on Darrell Brooks. Now, Darrell Brooks is the defendant in a case surrounding the incidents that happened in Waukesha. There was a Christmas parade, and he drove right through it, killing 6 people. What makes this interesting, from a legal standpoint, is that Darrell Brooks is trying to defend himself. Have you ever heard that old adage, he who represents himself has a fool for a client? Well, that is the case here. But he also has some other very interesting issues. He claims he's a sovereign citizen and that the state needs to prove that he's a human being. There's a whole lot of tax protesters, sovereign people, they say that they're an entity, they're not a person, whatever the fuck that means. It's just so funny when you see these guys do this because all they really are doing is trying to throw anything against the wall to stick, to muddy up the waters. Now, he has claimed to have hearing problems, even though the day before he's not having hearing problems. He's disruptive. The judge has had to have him in another courtroom. So let's just take a look at some of his antics.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking...
First of all, this is a 6-person homicide, so 6 deaths. And so you can see by, the boxes that there's a lot of documents.
You to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to...
And here's the other thing. He continues to interrupt, like I'm interrupting the video. He continues to interrupt the judge. And the judge has got to be a little bit careful because you're dealing with a pro se. Pro se means that you represent yourself. But when you're a pro se defendant, it doesn't mean that the rules don't apply to you. And you can't claim ignorance of the rules. So you have to be just as adept as an attorney.
To get through this morning.
The trial for Darrell Brooks, the man accused of driving through the Waukesha Christmas parade last year, killing 6 people, begins, and Brooks is representing himself as a sovereign citizen.
So, sovereign citizen is just a total fiction. You're part of the community, you're subject to the jurisdiction in which you're living. Let's just talk about the difference between somebody who's representing themselves and somebody who isn't. There's a distinct advantage to representing yourself and a distinct disadvantage. The disadvantage is pretty obvious. You don't know the rules. You don't really have the ability, basically, to conduct a fair trial because you're behind the 8 ball in terms of knowing what to do and how to do it. But the advantage, guess what the advantage is? He gets to give a closing argument. And when he gives a closing argument, that's him talking. And when he's talking, you can't cross-examine somebody during their closing argument. And so he can get up and say whatever the hell he wants, well, within reason, and nobody can cross-examine him on that. Although this is just going to be a slow guilty plea anyway.
It is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
So when you have the constitutional right to not be perceived as being in custody. So because the argument is that, if they see you in jail clothes, that you're going to be found guilty just because you're in jail clothes. So when I'm about to start another trial right now myself, and so they'll put my client in a suit, and it's not a big deal. but you don't want the jury to see you in jail clothes.
Mr.
Who
Brooks,
doesn't know that?
I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again,
I don't know if I was this judge, after all the crap he's put her through, if I would go as far as she's going, but she's super patient.
it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody.
So it didn't matter what the judge would say. The judge would say, "I don't want you in those clothes." He'd say, "I want to be in those clothes." The judge would say, "I don't want that evidence in." He'd say, "I want it in." She would say, "I want it in." He'd say, "I don't want it in." Whatever the judge says, he's going to say the exact opposite.
I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
More interruptions. We'll be off the record while we do that. Thank you, everyone.
I don't agree to a stop, or I'll move for a motion to dismiss.
So he just said he has shocks on his ankle. So what that is it's a device that you put on. In fact, in one of my last trials, I had a client had a device, a knee lock. Well, this is a shock device. So the deputies can shock him if he either tries to charge the judge or tries to escape or whatever. So that's what he's talking about here.
For being under duress and being coerced into a contract that I did not consent or agree to.
So you saw that what the judge just did. She walked off the bench, and because he just won't stop talking. And so the remedy for that, when you're being disruptive in court, they can do one of two things. And I think they did this in this case. They put him in another courtroom so he can watch it and he can participate. But the judge has the ability to stop what he's saying. Obviously by if he's appearing by Zoom, or they can gag him.
I have a right to be present for trial.
All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks.
Now, you might think that somebody like this isn't playing with a full deck, which, in order to establish that somebody is incompetent to stand trial, you got to show that they aren't capable of aiding in their own defense. And he clearly is, because he's writing briefs, he's doing everything, but he's trying to be as disruptive as possible.
On every day that we have been in court since Monday, he has shown a complete and utter disrespect for these simple rules of civility.
Here's the other thing. You see him, he's sitting there with his shirt off. I mean, what the fuck is that? And this judge could restrain him. I mean, he's standing up. They got the ankle electrical devices.
He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to...
See, she can order him to be restrained to a chair. You don't have the right to just do whatever you want in a courtroom.
With the Secretary of State.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking
They were not certified, Your Honor.
questions like this.
I am not.
I realize it may very well be related.
And, here's the thing. The judge is engaging him too much, I think. The judge really needs to take more control. But she wants to make sure that there's a record of everything and that it's never perceived that his rights aren't being observed.
To your claim to be a sovereign citizen and
disputing
the
claim to be sovereign. That's correct.
Jurisdiction of this court, but these are not questions this court is obligated to answer.
I would like to correct the record and say that I am sovereign.
All right, you believe you're sovereign. The record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line.
Really close to crossing the
Being
line.
removed from the courtroom for continued interruptions.
I
want you
consent
here.
to that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning.
haven't.
It is only, it's 8:57. I want you to be here. Certainly my preference for...
So that you can see that the judge just removed him again from the courtroom. You don't have the right to be disruptive. The judge can conduct you have the right to be present during your trial. But if you interfere with that right by being disruptive and by being just a shit, which is what he's being,
of his interruptions of the court, and
so you can see
I understand he objects. His objection is again once is noted, and because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday.
You can see he's not listening. She's got him in another courtroom.
It's the Pennsylvania case,
and it's never going to help him.
Found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the... I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well.
So basically, he's been examined 4 times. He's trying to, he knows he doesn't have any defense to this case. He knows that. I don't really have a motive as to why he did this. Why he's acting this way, other than just to gum up the works. But the mental health evaluations don't show anything other than malingering and manipulation. So here's the other thing. When you have a pro se defendant and he's cross-examining witnesses, the judge should put a tight rein on where he goes. He can't just be gratuitous.
Mr. Brooks, I need to turn to you first and see if there's any issues you believe the court should address.
Very briefly. I just want to state this for the record that I would like to issue the court an apology for me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial, the families here that have to go through, everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that.
So that just shows you that he knew what he was doing and he was just being an asshole. And all of a sudden now that other people are going to be watching the trial, he's taking a different tack.
I wasn't raised that way. And I owe you, Your Honor, and the court an apology. And I want to stand up as a man and tell the whole court and you, Your Honor, that I apologize to the bailiffs, that I apologize for my actions. Like I said, that's not how I was raised. I come from a Christian background. My mother did not raise me that way. She did not raise me, to act out.
But he said he was going to be very brief.
Are you a party to this matter in any way?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained, it's not relevant.
Do you have a claim in this matter?
Objection. Irrelevant.
Grounds.
Sustained.
Have you read the complaint in this matter?
Objection.
Grounds.
Irrelevant.
Not relevant, sustained.
See, this is the problem. When you don't know what the hell, he has no idea why he's even asking the questions that he's asking. And so that's the danger of representing yourself.
Do you know who the plaintiff is in this matter?
Objection. Irrelevant.
Grounds.
Sustained.
Did you observe the vehicle strike anyone when you attempted to stop it?
No, I did not.
Did you see the vehicle strike anybody before it approached you?
No, I did not.
Those are actually good questions.
Would it be fair to say that there were hundreds of people present at the time that you attempted to stop the vehicle?
Yes, there were hundreds of people there.
And you saw no one struck by the vehicle?
That is correct.
Did you see if anyone else was, could you see rather, if anyone else was in the vehicle?
I did not see anybody else in the vehicle when it passed my location.
No, it's just you.
Do you recall there being any tinted windows to the vehicle you attempted to stop?
I do not recall the passenger front or the passenger rear being tinted. I believe that the rear windows on the SUV were tinted.
So it would be fair to say that from your vantage point, you wouldn't be able to see the entire seating of the vehicle you attempted to stop?
Objection. That's a misstatement.
Grounds.
Overruled. You can answer the question.
See, there he goes.
Could you re-ask the question, please?
Would it be fair to say that because of the tint to the rear windows that you cannot visibly see the seating of the vehicle that you attempted to stop?
I did not see anybody in the vehicle. I don't think that the tint had any reasons for me not to be able to see in.
So it would be fair to say that you could clearly see the seating of the vehicle you attempted to stop, front, passenger, and back seat.
From the limited view that I had, I thought that I could see it.
So this actually was a good line of questioning because he was trying to call into question the witness's credibility. Don't think it really is going to help him a ton. It's better than all the obstruction bullshit that he was trying to do earlier.
Step out of the way so you yourself are not struck. Is that fair to say?
Objection. Reading the witness.
Sustained, please rephrase.
Sustained. Look at this guy go. When the prosecutor calls a witness, she can't ask a question like that. So in other words, a leading question is a question where you say, the sky was blue on the day in question, right? That's the leading question. You have to ask, what color was the sky? And so he just had a decent objection, and it was sustained.
As you stood in the middle of the road, facing the vehicle, did you stay in that position?
I did not. I was very concerned the car was going to hit me.
So what did you do?
I jumped out of the way.
Did you make any efforts to interact with the vehicle in any way?
I believe that I had hit out at the car.
Okay. Were you able to see the driver of the car?
I was.
What did you observe about the driver of the car?
It looked to be an African-American male with brown eyes and brown hair.
So notice he's changed his appearance. We'll show you the juxtaposition over here. So you've got him with hardly any facial hair, and he's almost a shaved head, which isn't how he looked that day at all.
The driver of the SUV react to your presence in any way?
When I observed the driver, he had no expression on his face and he was looking straight ahead, as if he was looking straight through me.
And that never changed?
No.
Did the driver of the SUV follow your direction and leave the parade route at Buckley?
No, he did not. As a matter of fact, he appeared to speed up.
Would it be fair to say that that was just a horn that was heard?
No, I don't hear a horn.
You don't hear a horn?
I do not hear a horn.
Can we start that from the beginning?
Sure. For the record, Mr. Brooks.
Objection, asked and answered.
Objection. I do not consent to being called that name, Your Honor, nor do I identify by that name.
The defendant has asked the video to be stopped. It was stopped at 4 seconds in. He's requested that it be replayed. Are you going to have the whole thing replayed, or do you want it stopped again at 4 seconds?
So that's just a little snippet. I mean, he's going to be found guilty. So that's just a little snippet about Mr. Brooks. Mr. Brooks has got some antics, and we'll show you a couple other examples throughout. But he considers himself a sovereign, not a sovereign citizen, whatever that means. He doesn't consent to the jurisdiction. He's putting up every roadblock he can. And all of a sudden, the trial is going to start, and the judges are basically going to let him get convicted without him being in the trial, in the courtroom itself. And he decides to play nicey nice. And actually, when you see him here, he's conducting himself actually quite well for somebody who's pro se. So this is Bruce Rivers. We'll follow this, but this is just a slow guilty plea. He's going to have 6 life sentences at least. He's got 76 counts or something. It's over 70 counts because there's all kinds of people, a lot of attempted murders, I'm sure. I'm Bruce Rivers. Make sure you subscribe. Follow us on Instagram. Follow us on Twitter. Follow us on Patreon. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please, is that my God?